go on to how to bring a 14B motion. That would be awesome. I think we're
Okay,
ready to do
all
that.
right. One of the first things I'm going to warn people about, and it's
Yeah,
horrible, and people are just going to roll their eyeballs, especially if they're in the middle of a court proceeding and they're trying to figure out if they've got something they can do by way of a Form 14B motion, which
yeah,
is another thing, because a lot of the stuff we've been talking about are all things that you do at the front end of a case, like
right.
before
Makes
case
sense.
conference or anything else. But you can bring a Form 14B motion, depending on what you're asking for, at any point as your application is progressing.
Right.
So it could be you might have already had your case conference and settlement conference,
Yeah.
and you need to do something like, yeah, if you have to set up cross-examination of an expert or something to prepare for trial, and you're not sure what the process should be to set that up, you can bring a 14B on a 14B motion for directions on saying, what are the rules about how I can cross-examine this expert for the other side? So you can do a Form 14B at any point.
Right.
So now what we're going to look at is we've talked about the different kind of things you bring a Form 14B motion for. You've got something that you think can be done by way of a 14B, and now you're just trying to figure out, okay, how do I actually do this? What are the nuts and bolts of how it works? So that's what we're going to go into now. How do you
Right.
bring a Form 14B motion?
Right.
First thing, and this is where I started, people are going to roll their eyeballs. Every court jurisdiction does things a little bit differently, and the order that they do the forms and the things that they need. Like for example, there might be some jurisdictions that specifically say, if you're bringing a 14B on consent, we need to have that form called a consent that you have to draft up because there isn't a set form for it in the family law rules. We won't accept an email confirmation that the other side's agreeing to something. You actually have to do a formal consent. There are other jurisdictions that might say, well, as long as you do your affidavit and you show that the consent is set out and you're swearing to it in your affidavit, that's good enough. So always what you need to do, depending on the region that you're in and what court you're going to, you should always read the practice directions and the notices to the profession that affect your area, because the rules are in play right across the province. But as I said, different jurisdictions have got little quirks or things they want or need or whatever that they might not need in
Mm.
another jurisdiction. So
Mhm.
make sure before you do your Form 14B that you see if your local practice directions or notices to the profession in your area has anything to say about what has to go in a Form 14B and when you can do it. So that's the first thing you need to do before you even start looking at trying to complete forms, is make sure this is actually going to work in your jurisdiction.
Got it.
So the first step you need to do is what you'd expect. You have to complete the Form 14B motion form. Okay. That's okay. And we actually skipped a little bit of scrambling around. So I am screen sharing now. Can you see my screen?
Yep, I can. Excellent.
Okay. So what I did is I just took us to the Ontario Court Forms website.
Yep.
So this is where the repository is for any time when you need a family law court form, any of the ones that have like forms that are template documents,
Yeah.
you can find them here. And again, the way the forms are numbered is the form number always relates to the family law rules that governs whatever it is you're using that form for.
Right.
So Rule 6 is the rule about service. So
Mhm.
again, this is just set up. So anything that has form numbers like the 6, the 6A, the 6B, the 6C, those are all about service. So that's where your affidavit of service is. Then a lawyer can do a certificate of service if you're doing an advertisement for service, and then 6 is an acknowledgement of service. So anyway, we're going down because remember what we said, Form 14Bs are a motion.
Right.
Motions are governed by Rule 14. So if we just skim down,
Yep.
here's all the stuff that are with the forms numbered by 14. These are all the forms that relate to motions. The normal notice of motion, the straightforward motion that everybody knows and thinks about is just a Form 14. 14A is the affidavit you do in support of a motion.
Mhm.
And lo and behold, there's a Form 14B motion
Right.
form. And it was one that was specially created under the family law rules to be able to deal with procedural, uncontested, uncomplicated matters. You don't have to have people appearing before a judge and argue about it. So if
Right.
you want to pull up that form, then you would just click on that link and it will actually pull up the document. And I've already done that. So now,
Right.
and actually they're trying to make this as simple and easy as possible. So
Right.
again, I had in my mental brain picture, I was saying it's always the same style cause. Remember what we were
Right.
talking about? Always the
Yes.
information once you start an application, what always stays the same up at the top. They've
Yes.
made it a little bit simpler. So when you're doing your Form 14B motion form, you can pull it off the Ontario Court Forms website. That's just where I got this one.
Yeah.
So this would be your court file number would go here.
Yeah.
The name of your court, the
Yeah.
address of the court. So all of this stuff would be standard.
Right.
And again, for those that might always try to just print out their documents by hand, sometimes it's really handy dandy to use the electronic, whether you're in Ontario Court of Justice, the Superior Court of Justice, or if you're in the Unified Family Court.
Okay.
So now you just go through and fill it out. I am making this motion.
Yeah.
Or I'm responding
Right.
to a motion, which
Yeah.
means the other side has already done a Form 14B. So when you're responding to, well, this is maybe something I should have talked about. When you're responding to a Form 14B, you could just be responding to say, this is what the other side is asking for, and I disagree with it because blah, 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 blah. But well, guess what? I've got something I want to do too. I'm bringing a cross motion by 14B. So that's what you would use the second one for. So if you're the one bringing your motion, you're the one making the motion, or if you've been served with the Form 14B, you're saying, well, I got served with one, but I want to make a motion for a 14B too, and you can do it by using this form.
Interesting.
So again, this is where the names of the parties would be the applicant and the respondent names. If your matter has got an upcoming court date that's already been scheduled, you put that in. If you're already in the process and you have a case management judge, you put it in. A lot of parties don't know this stuff, or you might not have an upcoming court date. So you just put not applicable or not applicable if you don't know. That's not going to be a game killer. It's you can, if you don't know, you just leave them blank. And again, this form is filed by, if you're the one making the motion, are you the applicant or you're the respondent or are you another party? So that's really, really rare. So you'll either be the applicant or the respondent. And this motion is being made with the consent of all persons affected, or just with notice that to all persons affected. So you've let them know. They might not necessarily have agreed by consenting, but they know about it, or it's being brought without notice to, and then you would put in whoever you're bringing the motion without notice to. Now it's very clear, notice to person making this motion. You may not serve or file a reply. So you can't keep going on and doing it, because normally the process on a motion is you do the motion, and then the other side can do a response to motion. And if they say something in their affidavit that the moving party doesn't like, then the moving party gets to do a reply. So when you're doing a Form 14B, you don't get that third step. It's just the moving party does their affidavit saying what they want. The respondent does their responding affidavit. The person bringing the motion can't come back and then say, but I want to answer to what the respondent had to say. You don't do that third step, because this is supposed to be fast, easy, simple, uncomplicated, uncontested, right?
Right.
So it tells you can't file a response from any person affected by this motion if you're the one making a motion. Okay, this is where it gets, you can also use the Form 14B to do a consent motion to change child support on a temporary basis, but I really would very rarely use it for that. That's the whole Form 15 motion to change child support on consent would be a lot better way to do it. But this is just a heads up that if the parties are agreeing they want to change the support and they're trying to do it this way, if the support's been assigned to community and social services, then you've got to serve family and social services too, if that's what it's about. So again, then it tells you if you're getting served with this motion, if you want to oppose the motion, you have to prepare a response by completing your own motion form or an affidavit, and serve it on all the parties, file it at the court office, and it gives you your time frames. You got 7 days. If you do not respond in time, the motion can be dealt with as unopposed, and the court can make an order based on the information provided. So like they give you a lot of the information on what to do. So again, notice to everybody, the court will deal with this motion by relying on written materials unless the court deems it necessary to hold a hearing. This will only be done in exceptional circumstances only. If you believe that a hearing is required, please provide reasons below. So then you do the procedural, uncomplicated, or unopposed order you want the court to make. So this is where you list what you're asking the court to make an order about. And then you've got why the court should make this order. And you put the reasons why you need this order. And then the laws and rules on which you're relying, this is where you get to bring a motion because of what's happening. If there are other things like if there's other legislation or something that happens, or if a bank has told you that they need a court order in order to do something in accordance with the Banking Act section, blah, 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 then you would put in that section from the Banking Act there as well. And then if the parties have got lawyers, then you put in the lawyer information. And that's it.
Well, this
You're
is
done.
pretty simple.
Yeah, like I said, that's meant to be a really quick, uncomplicated, fast and easy way to get a quick, uncomplicated, and on consent, if it's happening that way, order from a judge. So that's how you do it. So that we've just walked through the motion form, that's how you complete it.
Okay.
Then if sometimes you don't even need to do an affidavit if it's really, really clear. But like, let's say if what you're doing though is you're asking for an order for substituted service,
Mhm.
you have to do then the Form 14A affidavit with it, where because you have to give the court all the information and the facts about what you tried to do to serve the other side and you just couldn't do it.
Mhm.
Then you attach any other necessary documents to the notice of motion. So you'll have your motion form, the Form 14B motion form, you'll have a 14A affidavit, then any other documents. So this would be ones, if you've got a consent, you would do that. If you're just filing an email exchange where the other person says they're consenting to late filing, that would go as an exhibit to your affidavit. So you attach any other documents that are necessary. Now, this is where sometimes it gets hard for people. You have to prepare and attach a draft order, including the terms you're requesting the court to make. So if
Mhm.
at all possible, you should take the order template form from the rules
Mhm.
and complete it and fill it out and basically put in this court orders that. And you can pretty well, you should be able to cut and paste from whatever it is what you're taking from your Form 14B, the motion form, what you're asking the court to order. So once you've got all that stuff done, then you take the motion materials and you serve them on the other side, even if they did provide a signed consent. So even though they've agreed to you bringing the motion, they need to know that you're actually bringing the motion. So you have to serve them with your motion materials. And then you have to do the 6B affidavit of service confirming you've served them. And that again, it's an affidavit that must be sworn or affirmed. And then you have to file the motion materials with the court and the upload to case lines. Now, the one thing that you will notice what is different with the Form 14B than a normal Form 14 motion. There is no line on the Form 14B that says this motion will be heard on
Yeah,
such and such a date at such and such a time.
right.
Because it's not being heard. It's a basket motion. You're just filing it in the way of material. It goes before the judge. The judge will get around to reading it when the judge can get around to reading it. Nobody's expected to attend. There's no hearing. There's no court date you have to go to or anything else. So that's really where you see the difference on the Form 14B and the other motion form is that there isn't a specified date where it's going to be heard.
Right.
Okay. So then you file the motion materials with the court and then you upload them to case lines.
Right.
So what happens? How do you respond to a 14B motion if you didn't provide a consent for the motion? You've been served with the Form 14B and you want to respond. Then once you get served with that motion material, the Form 14B motion form and the affidavit and the draft order, whatever else is attached to it, once you get served, you have to serve and file a response within 4 days. Again, it's a really, really short turnaround time. You can file either a responding 14A affidavit,
Mhm.
or you can also serve and file the 14B motion forms if you have an order that you want the judge to make that wasn't asked for by the other side. So that goes back to like the instructions that we kind of reviewed when we went through the Form 14B.
Mhm.
If you do not respond to the Form 14B motion and the materials with it, then the motion will be treated as unopposed. So the judge will go ahead and just read the moving party's materials and go ahead and make their order.
I
Okay, so
understand.
now the judge is, yep, so the judge has got all the stuff. There's either a response or there isn't. The judge will make sure that it was properly served. The judge will review what's being asked for. The judge will decide whether to make the order that is being requested on the Form 14B motion form and in accordance with the draft order that's been filed.
Mm.
So the judge will review all the motion materials. If the 14B motion materials are complete and the judge has no questions,
Mhm.
then the judge will sign the draft order that the moving party has provided.
Mhm.
Once the draft order is signed, then the clerk of the court will send a certified copy of the signed order to both parties. But if the judge reads the materials and still has some questions, and the judge isn't quite sure if he, she, or they wants to sign this order yet because they are not quite sure of something. If the judge has questions for you or the other side, then the clerk will contact the parties with a court date. or provide you with a copy of the judge's endorsement, which will set out any additional steps that should be taken. So does that make sense?
Yes, just a quick question to clarify. The part where you said the judge will sign the draft order. So I'm assuming that you don't have to, I mean, the court automatically, this is automatically filed at court. You don't have to like, I don't know if you know what I'm saying. Because, a lot of times, you do things and then you assume the court has it and then they don't. So for this draft order,
Let's just sit back and reload. Remember we said if you were bringing a Form 14B motion,
yeah,
what are the materials you have to have? You have to have the Form 14B motion form.
yeah,
You have to have the 14A affidavit in support.
yeah, and
You have to have the consent,
right, if
and
you
you
have
have to
consent,
do a draft order.
right,
So you do an order assuming like an actual typed up formal order, assuming the judge is going to grant the order that you've requested.
right.
If everything is okay with your motion materials, the judge will actually take that draft order and date it and sign it.
And
And
that
then the
becomes the
court will
order.
issue it
Yeah,
and it's done. Yeah,
and
you've
that's it.
actually got the
Oh,
draft order. The judge signs the actual order.
I see. Okay.
If the judge doesn't like your actual order, or if there's a
Yeah.
problem with the order, or if the judge needs some more information, that's where this other stuff kicks in. The judge will say, no, I want to hear from the parties. And then the clerk will
Oh,
notify both the parties and give them a court date. It'll probably be by Zoom where they would attend so
I
the
see.
judge can ask the questions the judge needs to ask before the order will be signed. Or what'll happen most often, the judge will read the motion materials and say, yeah, not quite, I don't have enough information to sign this order yet, or I'm not clear on a couple of things. So then what the judge will do is rather than signing the draft order that you've provided, the judge will do an endorsement. And okay, so this is where we talk about the difference between an endorsement and an actual order. An
Right.
order is a formal document that's been taken out by the court.
Right.
Okay. The endorsement is actually the judge's ruling on a case. The endorsements will either set out the terms of what's going to go in the formal order, or they're going to say there's something else that needs to be done. So
Okay.
again, what would happen in this case, the judge here reads the 14B stuff. There are other things that he thinks or she thinks that the parties that brought the motion needs to do before the motion can be granted.
Mm-hmm.
So the judge will make an endorsement saying,
Mm-hmm.
on this date, I have reviewed the 14B motion materials filed by the moving party, who in this case is the applicant. Before I will consider issue, or before I will make this order, the party has to take the following steps or provide the following information. And the endorsement will go out to the party and say, okay, the judge has reviewed all this, and the judge says in the endorsement, but in order for me to sign this order, these are the other things I need you to do. And there'll be a timeline given for when those things have to be done by, and specifically what the judge is looking at. So the judge can give directions on saying, in the endorsement, you got to do this, 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 and this before I will sign the draft order. So that's
Okay.
always what it is. So again, we had an interesting discussion before we started this taping again, where you asked, what is the difference between a judge's endorsement and a judge's order? Okay, whenever a judge makes a decision on a case, either on a temporary basis, on a motion, or on a final basis after trial or whatever, the judge will either write in hand, or the more techno-literate ones will actually use their laptop or computer and they'll type out their endorsement, where it says, I have heard this proceeding, I am making the following orders. And the judge will write out or type out his or her decisions using usually a little bit more informal kind of language, but including what is there. And then what will happen is the endorsement is the actual decision the judge has made. So the decision becomes binding the day the judge does the endorsement. Okay, but then what happens is either the parties or the court staff, if the parties don't have a lawyer and nobody takes out the formal order, they will review the judge's endorsement and then they will do the final order based on what the judge put into the endorsement. And the final order is a lot more formal language, and it includes stuff that might not have been in the judge's endorsement because it automatically gets added into an order when the order itself is made. But then it's the order itself that gets issued and entered, but it is always based on the judge's endorsement. Again, on the Form 14Bs, because they're trying to save time, says
Mhm.
if the judge is okay with what you've asked for and your draft order is fine, the judge won't even do an endorsement. The judge will just sign the draft order and it'll
Straight to
come
the
back.
draft order. That makes sense.
Yeah. But if the
Yeah,
judge says, a couple of things I need to know still, there's some further stuff I need the moving party to do, I need the following information, and then send it back to me when you've done this, blah, 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 that will be in the endorsement. And that endorsement doesn't necessarily have to be taken out as an order because the endorsement is
right,
effective the day the judge makes it. Now, one of the interesting things about endorsements and orders, and even sometimes lawyers get confused about this, is let's say that you have an argued motion for temporary child support.
right,
And the judge makes an order that says effective April 1st, the respondent shall pay to the applicant child support on the table amount of X based on the payer's gross annual income in 2024 of Y.
right.
And the judge makes that order on March the 24th. Okay, there are some people that say, well, that's just the endorsement, but let's say the order doesn't get taken out. The formal
Hmm.
order doesn't actually get done for a couple of months.
Hmm.
They say, oh, well, it's not an order. I don't have to do anything until I actually get the formal order is issued and entered. No, orders speak from the date the judge makes their endorsement. So if a judge told you on an endorsement made on March 24th, that you owe child support starting April the 1st, if you don't start making payments on April the 1st, the order is going to get filed with FRO. Eventually, final order is going to get taken out and filed with FRO. They're going to see when the support was supposed to start, and you are going to be in arrears if you don't start paying when the judge says you have to start paying. You may not be able to pay FRO yet because they don't have your case set up, like if we're talking about a child support issue. But orders always speak from the date the endorsement is made. From the date the judge makes a decision, that is a binding court decision. It's a court order. The order that we keep talking about is the formal order, which is the formal typed out, complete, absolute version of what the judge's decision first was made that's in the endorsement.
So a common question would be if nobody uh, went to the trouble to actually make the formal order, then would they say, then who cares? Like,
What'll happen is if you ever have to produce the document that shows what the court decision was, you have to have the formal order issued and entered. The formal order has to go to FRO. If you are trying to enforce an order,
yeah.
you have to take out the actual formal order and have it served on the other side before you can follow any kind of enforcement proceedings for anything other than dealing with support with
Okay.
FRO.
Right. So
The
it is
FRO is
really
a little bit.
important that you don't skip that step, that you have to do the formal order. You don't just sit on it, or you don't just,
And
right?
a lot
Like,
of parties do, and it's so hard because they do that,
oh,
and that means then like they might get an endorsement for an order,
yeah,
and it's a temporary order. Nobody ever takes out the order, and let's say
that's
that
right.
it's a temporary order that says kids
Yeah.
live with the applicant Monday to Friday, the kids are with the respondent every other weekend from Friday night until Sunday night. Well, one Sunday night, the other parent does not return the kids to the party who has the children on a day-to-day basis. The police will not enforce based on a judge's endorsement. They need to see the formal court order is issued and entered.
There
So
you
again,
go.
that's the final stamp. That's closing the loop. It's making sure all the paperwork jives with what the actual decision was in the case. And it gives you the formal document that you need in order to ensure that the terms of that order are being followed.
Yep. That's important to know. Okay, good. Good. Okay.
And I think we're done.
We're done.